Mr. Miller?
Yes,
Come up. On the record in the matter of the people of the state of Michigan versus Brian Miller, file number 22-01079FY. Have your appearance, counsel.
Jessica Shaw on behalf of the people.
And then Mr. Miller, you're proceeding without counsel today, correct?
yeah, still, I gotta get pretrial services. Called me yesterday, I couldn't find my last year's tax reform, so I gotta give that to him today, man.
So, Mr. Miller, you have the right to have a preliminary examination within 21 days of your arraignment. You were arraigned on July 12th. Your preliminary examination was scheduled for today, but due to the fact that you're seeking to get a public defense counsel and your application is still under some review because of your denial and your resubmission of the application, I'm going to find good cause to waive the timeline on that to go beyond the 21 days so I can get you a new date to come back, okay?
All right, thank you, man.
I'm going to set it for a new PCC and a new exam. We can do a PCC August 5th at 9:30. And the exam can be August 11th at 9:30. Okay, so your new probable cause conference will be August 5th at 9:30. We'll do your exam August 11th at 9:30, and we'll get you a copy of your notice to appear for those dates. Okay, sir?
Okay, thank you.
Do you have any questions today?
No.
Any additional matters today, counsel?
No, Your Honor.
Okay, you have a seat. We'll fix your copy.
All right, thank you.
No problem. The record in the matter of the people of the state of Michigan versus Jimmy Clark Jr. File number is 22-01822FY. Counsel appearance, please.
Jessica Shaw on behalf of the people.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Jimmy Clark, gentleman who stands tonight.
Thank you. Today was a date that was set for a preliminary examination. Are you ready to proceed?
Yes, Your Honor.
Are there any preliminary matters?
I believe it's only going to be one witness. So, yeah, no other preliminary matters.
Okay, sounds good. You can call your first witness.
Thank you, Your Honor. The people call Officer Sagar Kendall.
Officer, do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Thank you. You can have a seat there. State your first and last name and spell them both.
First name is Sagar, last name is Kendall, spelled S-A-G-A-R, last name is K-A-N.
Proceed, counsel.
Thank you, Your Honor. Where are you employed?
I'm in front of the building.
And how long have you been employed there?
Just over 3
And this is as a police officer?
years.
Were you working on July 11th, 2022?
I was.
And while you were working on that day, were you patrolling in the area of Cedar and Mount Hope in Lansing County, Michigan?
I was.
And what, if anything, did you observe around 3 in the morning?
During my patrol, I was in that area of Cedar and Mount Hope near Mount Hope and Teal, which is just to the west of Cedar. While on patrol, I observed a white color sedan at a closed business. It was parking warning at unusual time. That area I've worked in has had high crime area before, so I've been monitoring the business.
Okay, I'm gonna stop you for just a second. Were you in a marked patrol vehicle?
I was.
And were you wearing your police uniform?
I was.
All right, and you indicated that you saw this white sedan at a closed business?
Yes.
And was it in the parking lot of a closed business?
I was.
All right, and you indicated you started monitoring it because of the high crime area?
Yes.
Okay, and what happened after you monitored the business?
I started doing that. The vehicle pulled out of the parking lot and began heading eastbound on.
Can you speak up for me, Tom?
All right, and what happened as the vehicle was pulled out of the parking lot?
As it pulled out, started heading eastbound, and as I tried to get behind the vehicle, it made another sudden turn into another closed business that was at Cedar and Mount Hope.
Okay, so when you were trying to get behind the vehicle, what street was the vehicle on?
It was on Mount Hope.
And how many lanes of travel are there on Mount Hope in that area?
The eastbound lanes has 2 lanes, and there's a turn lane as well. It's a total of 5 lanes.
Was the defendant driving in the right lane?
Yeah, the most right lane should be the southern lane of Mount Hope.
And when you indicated that the vehicle made a sudden turn, can you please explain that?
Yeah, it was from the right lane, made past, it went past 2 lanes, cross over the westbound lanes and pulled into a liquor store, which was closed.
So it pulled into another closed business. It made a sudden left turn. Is that what you're indicating?
Yeah, sorry.
All right, and then what happened next?
As it did that, I initiated a stop on it in the parking lot, as it was trying to leave that as well. And then I started my stop from there.
And did you make contact with the vehicle and occupant?
I did.
What happened after that?
I asked the driver to turn the car off multiple times. Took them several attempts for him to do that. After he turned the car off, he rolled the back windows down. When he did that, I observed him reaching in the car. He was trying to conceal something under the seat in that area, and I went up to him and I asked him to step out of the vehicle at that point.
Okay, so when you say you saw him reaching in the car, can you describe what you saw, please?
He was leaned forward. Hands were not visible to me at first. It appeared that he was putting something or concealing something under the seat as he leaned forward.
Okay, and this is the driver's seat you're talking about?
Yes.
Okay, and what happened next?
After that, I asked to see his hands. The driver complied with that, and I approached him and I asked him to step out of the vehicle so I could talk to him better. The front windows were not leaned down.
All right, and then were you able to speak with the defendant?
I was.
And at some point, did you obtain consent to search the vehicle?
I did.
And did you search the vehicle?
I did.
All right, what happened when you searched the vehicle?
As I got up to the driver's side, I immediately noticed a handgun right on the floorboard, which would have been between the legs of the driver, which was consistent with where I saw him moving forward.
Okay, and what kind of firearm did you see?
I would have to refer to my report for the exact details. It was a pistol.
And can you describe the position of the pistol when you first saw it?
Yes, ma'am. It was, the muzzle of the handgun was facing to the rear, which would explain the only way that would happen was if someone was trying to conceal it from the driver's seat, so the muzzle was facing the back seat of the vehicle.
And do you recall if this pistol was loaded?
It was, had a loaded magnum on it.
And was there anyone else in the vehicle at the time you made the stop?
Yes, there was a passenger in the front passenger seat.
And the driver of the vehicle, do you see that person here in the courtroom today?
I do.
Can you please point to him and describe what you're wearing, or what he's wearing?
He's over there wearing a yellow sweater.
Gotta make the record reflect that the witness has identified the defendant.
Any objections?
Not for the purposes of exam.
Identification is noted.
All right, and what happened after that?
After the firearm was recovered, I placed Mr. Clark in custody. Was transported to our Lansing City lockup.
I have no further questions.
Cross examination.
Thank you. Good morning, officer.
Good morning, sir.
So, look, I'm gonna start with, you authored a report in this matter, is that right?
I did.
And everything you put in the report would be true, is that correct?
Yes, sir.
All right. So, according to your report, it says that you first noticed that the vehicle was idling in a closed business, correct?
Yes, sir.
All right. And you indicate that this is a business that's in a high crime rate, correct?
It is.
And at that time, other than the fact that the business was closed, that the vehicle was idling in the business, there's nothing in and of itself illegal about that. Is that right?
Okay, this is part there.
All right. And so you noticed the vehicle pull out, and at that time, you're going in an opposite direction. Is that right?
It was, yeah, the vehicle's going to the opposite direction of where I was facing.
Okay. All right. And so you started, at that point, you indicated that there was a right side headlight that was inoperable, correct?
Yes, sir.
And that's, I guess, just to be clear, inoperable on the vehicle, the white vehicle that you're talking about.
Yes, sir.
Is that a basis to stop the vehicle?
It's a motor vehicle for violation.
Is there a internal Lansing Police Department memo that says you're not supposed to stop vehicles for inoperable headlight?
There is a memo that says I can't stop for inoperable headlight after dusk hours. Yes.
You're not aware of any memo that says don't stop them for public safety reasons? Is that your testimony?
Can you repeat your question, please?
Sure. My question is whether you are aware of any internal Lansing Police Department memos that say do not stop a vehicle for a headlight that's out.
No, I'm aware of a memo that says I can't stop for a headlight.
So at this point, you turn around and you see, or the vehicle make the, I guess, sudden left turn. Is that right? Into another closed business.
Yes, sir.
And you put in your report that you, based on that, well, let me back up here. That left turn would be another traffic violation.
Yes, sir.
And you put in your report that at this point, based on your observations so far, you had reasonable suspicion to believe that the vehicle and its occupants were involved in criminal activity.
Reasonable suspicion. Yes, sir.
What is the criminal activity that you have reasonable suspicion to believe they're involved in at that point?
Well, like I explained, from my experience as a police officer, that the Mount Hope 2 area, I personally have responded to a lot of violent crime, property crimes in that area. And I believe as soon as I started monitoring the business, the vehicle left the parking lot. And as I turned my vehicle around to get behind it, it pulled into another closed business at 3 o'clock in the morning. So with all of that in mind, I believe that they may have been, vehicle may have been involved in some sort of criminal activity.
Okay. Can you tell me specifically what criminal activity though? In other words, can you tell me, were you investigating a retail fraud? Were you investigating a homicide, unlawful driving away? What is it that you had reasonable suspicion as to?
At that point, with that time of day, it could have been anything from B&E to any sorts of cases in that area. It could be thefts or anything like that, I wouldn't know at that time.
Okay. Okay, but I guess what I'm asking is, you're at this point with regards to this specific white car, you're not aware of any criminal activity that car is involved in other than potentially a civil infraction for traffic. Is that right?
If you ordered other things.
So you then approach the driver, and you ask him to shut off the vehicle. Is that right?
I do.
And you indicated that it took him a couple of times to shut the vehicle. Is that right? A couple of requests.
Yes, sir.
All right. And ultimately, he puts down the rear passenger, or excuse me, the rear driver's side window. Is that right?
Yes, sir.
And at some point, you become aware that the reason he put down the rear window instead of the front window is because the front window didn't work.
Yes, sir.
All right. And in fact, he couldn't even open the door himself because the front window didn't work, correct? Or the locking mechanism for that door didn't work. Is that right?
Yeah, I was aware of that.
Okay. And so it's when he puts down the rear window, he's also got his hands up. Is that right?
Not right away. I couldn't see his hands.
All right. But you're looking at him, you're not directly looking in the window, the driver's side window. You're sort of behind the vehicle and looking in through an angle. Is that right?
Yeah.
All right. And so it's your testimony at this point that he's sort of leaned forward in the vehicle, right?
Is that a yes?
I'm sorry, is that a yes?
Yes.
All right. Can you actually see where his hands are at this point?
I couldn't see his hands. They were like kind of in front of him.
In front of him. All right. His hands could have been on the steering wheel, right?
Could have been.
Could have been on for example, the key fob turning off the vehicle, right?
It was out of my sight.
Obviously. All right. So then when you approach him, he initially tells you that he was a little concerned because he had some marijuana in the vehicle. Is that right?
I believe so.
And you indicated that there was nothing illegal about the marijuana and there was no issues there, correct?
Correct.
At some point during this traffic stop, you asked him to step out of the vehicle.
I did.
What was the basis of asking him to step out of the vehicle?
Well, with my initial observation and fact that it took me a couple tries to get him to turn the vehicle off, and me observing him kind of maybe reaching in under the car, I was more comfortable talking to him outside of the vehicle at that point because I didn't know if there was anything in the vehicle.
Okay. So he steps out of the vehicle and at some point then you ask him if you can have consent to search the vehicle, correct?
I do.
And his initial response is, you do not have consent to search my vehicle because it's not my vehicle. Search the vehicle because it's not mine. Is that right?
Correct.
And so at that point, do you have any other basis to search the vehicle?
I do.
And what is the basis to search the vehicle at that point?
With my observation of being a closed business, with the time of day, and my observation with him reaching towards the under the car and stuff like that, I suspected that he was trying to conceal something under the vehicle. So I put a search for that.
All right. So at this point, you're investigating a crime, but you don't know which crime it is that you're investigating, or is that right?
I don't know what specific crime it would be, but I suspected there could have been one.
Is there any basis at this point to even believe that a crime has been committed at all?
I wouldn't know at that specific time about it being specific. So it's kind of a broader thing.
So you ask him to step out of the vehicle and you ask him for consent to search, which he denies, correct?
He initially, his first words were that he didn't want me to search, but after further conversation, he told me to search.
All right. Now, when you say that you told him that he could search, I think the words you used are, "Can I just take a peek in the vehicle?" Is that right?
I don't recall my exact words. I'm not sure.
All right. So I'll put it this way, would you disagree with me if you said, "Can I just take a peek in the vehicle"? Is it possible?
It could be possible, but I don't recall my exact words.
All right. Do you remember any conversation between you and my client wherein he then, after you, well, let me back up. Would you have any reason, well, You were wearing a body camera, correct?
I was.
And the body camera would accurately reflect what occurred that night.
It would.
All right. And so if the body camera video showed you saying, can I just take a peek in the vehicle, that would be accurate.
It would be.
All right. And at first, my client says, yeah, you can take a peek in the vehicle, correct?
I don't recall the wording.
All right, fair enough. But at some point, do you recall there being a conversation where he says, wait, are you going to peek or are you actually going to do a full search? Do you remember that?
I don't recall. I now remember. I don't recall.
Oh, okay. Do you recall if he actually said, in fact, I'm not consenting to a full search. You can take a peek through the window. Remember that?
I don't recall.
Okay. So ultimately, you end up searching the vehicle. Is that right?
Yeah, I did a full search once the firearm was visible to me.
Okay.
When I approached the driver's side door.
Okay. Well, let me ask you this way. Other than the consent issue, is there any basis to search the vehicle at that point, other than what I think you're saying is his consent?
I could have searched it for his wingspan based on my observation of him reaching over the vehicle and everything else that I explained before the stop was initiated.
All right. You can search within his wingspan.
Based
Right.
on him reaching it.
Now is that his wingspan under your knowledge of the law? Is that his wingspan at the time he's in the car, or is that his wingspan at the time you conduct the search?
It'll be at the time within the vehicle.
All right. Because at the time at the time the vehicle is searched, he's already in the back seat of the police car, correct?
Yes, sir.
And he's being detained at this point, correct?
Yeah.
And what is the basis for the detainment at this point?
Well, besides everything that I explained, he also was driving without a driver's license. So detained for that. We had yet to check him and lean an SOS for his driving status and everything like that. So
Okay.
Okay, that happened before the consent for search or?
the lean check,
Yes.
yes, ma'am. I'm sorry, the lean check was after. So.
Just thank you, Judge. And just to clarify with the judge's question, you're saying that the lien check which indicated that he did not have a driver's license occurred after the search.
He advised me he did not have a driver's license. I did the lean SOS check after.
Ultimately, did you run the registration of this vehicle?
I did.
Was the vehicle registered to my client?
It was not.
Now, you indicated that there was a gun found under the front driver's seat, correct?
Yes, sir. On the
All right.
floorboard.
Excuse me, on that.
On the floorboard.
On the floorboard. Okay, gotcha. Was the gun tucked up under the seat?
It was not tucked. It was visible from outside, so it was on the floorboard where right in between where his legs would have been.
And so, excuse me. So there was another occupant of the vehicle as well, right?
There was. Yeah.
And that individual was also removed from the vehicle.
He was.
Once you found the firearm, did you do anything to determine who the firearm might have belonged to or who it was registered to?
I did.
All right. And if you recall, did the firearm come back as registered?
It did.
Do you recall who it came back registered to?
I believe it was Mr. Crow's girlfriend. I do not recall her name.
That's fair. That's fair. Was it, if you recall, was it the same person who the vehicle belonged to?
Yes, sir.
So it's your position. Now when you searched from the passenger side first, is that right?
Yeah, I started. In this.
All right. When you were searching on the passenger side, did you see the gun at that point?
I did not.
Did you look into the driver's side compartment or the driver's side of the vehicle when you're searching from the passenger side?
I don't recall.
Okay. And then you came around to the driver's side and it's at that point that you saw the firearm, is that right?
Yes.
Did my client ever make any statements regarding the firearm?
Objection, Your Honor, here, sir.
I think it's a statement by my
It's
Fine.
his own, yeah,
by
but,
my client.
right, but that comes in as an opposing party statement. He's introducing his own party statement. He can't introduce his own client statement.
I'll move on, Judge. Were any admissions made that night regarding the firearm?
objection, Your Honor. It's the same question.
Yeah. I have no further questions. That's what it's trying.
Thank you, Your Honor. Okay, so you indicated that the defendant told you he did not have a license. Is that correct?
Yes, ma'am.
At what point did he tell you that?
It was in the first initial conversation. Before I had to unlock the vehicle.
You said before you had him step out of the vehicle.
Yes, ma'am.
And you also indicated on cross that you could see the gun as you approached the driver's side door. Can you explain that?
So as I was, the door was already open because I had him step out, and as I was walking up, I could visibly see him before I even started searching the driver's side. Let's see it from the outside.
Okay, so is this, when is this in relation to when you had him step out of the car?
One is the search.
When did you see the gun in relation to when you had him step out of the car?
After he was placing my vehicle and I went to search it, I searched the passenger side. I went around. Went to the driver's side, and that's when I saw it.
And then after the search is when you confirmed truly that he was, that he in fact did not have a license, as you stated, correct?
Correct.
And what happened to the passenger that was in the vehicle?
He also had, I do not recall the specific of the warrants, but he was transported to the county jail by another officer.
I have nothing further. Your Honor.
It's the passenger that was in the vehicle.
I would have to review my report, ma'am. I do not recall.
Was it the registered owner of the vehicle?
The passenger was not.
Thank you. Any questions based on that?
No, Your Honor.
Okay, thank you, officer. You can be excused. Do you have any further witnesses?
No, Your Honor, the people are.
Any defense witness,
I'm sorry.
any defense witnesses?
No, not today. Your Honor. Thank you.
Okay, you can proceed to argument.
Thank you, Your Honor. At this time, I would ask the matter be found over to circuit court as charged. The officer testified that he was patrolling in a high crime area in the area of Mount Hope and Teal, and that while he was patrolling this area, he saw a vehicle idling in a empty parking lot or a parking lot of a closed business. And he found this to be suspicious because it was 3 a.m. The business was closed and the car was just sitting there. So he began to monitor the business. He then saw he was also in his uniform in a marked patrol vehicle. The car left the business, traveled to another closed business. At this time, he observed that the vehicle had a light out, and also observed the vehicle make a sudden left turn from the right lane, crossing across another 4 lanes, turning into another parking lot. This parking lot was also a closed liquor store, a closed business. And this was 3 a.m. So at this point, based on all the circumstances that he described, it being a high crime area, the unusual movements of the car with closed businesses, the timing, as well as the public safety traffic violation, the officer conducted a traffic stop. He also had he had reason to believe that there was reasonable suspicion to believe that criminal activity was afoot, which is the standard for conducting traffic stops. He made contact with the driver. He obtained consent to search the vehicle. He found a firearm in the front. Before he even obtained consent to search the vehicle, he saw that the defendant was leaning forward initially when he stopped the car. It appeared he was concealing something under the seat. He could not see the defendant's hands. Again, this is all at 3 a.m. in front of a closed business. And the defendant also stated before he was even removed from the car that he did not have a driver's license, so he was not able to legally drive the vehicle. After that, a search was conducted and a firearm was located in the area where the defendant was sitting and where the officer saw him leaning over. So based on all of this, I believe that there is probable cause, and I would ask the court to find over the matter as charged.
Mr. Funk.
Thank you, Your Honor. I'm asking that the matter be dismissed for lack of probable cause. First of all, I have some concerns about the basis of the stop. Officer Kendall testified that he started investigating this vehicle for because he believed it to be involved in criminal activity, except he can't name what criminal activity it is that he apparently believes that my client is involved in at this point. He conducts a traffic stop. There is an issue with regards to consent to search, even though Officer Candell seemed to believe that he had consent to search from my client. I think that that is an issue. More importantly, Your Honor, under 11.1A, which is the jury instruction for carrying a pistol in the vehicle, there requires 3 elements. First, that a pistol was in a vehicle that the defendant was in. I'm not going to debate that one. That one seems pretty obvious. But second, that the defendant knew that the pistol was there. And third, that the defendant took part in carrying or keeping the pistol in the vehicle. I don't know that we've heard evidence for those 2 elements. We did hear today that the vehicle did not belong to my client. It belonged to someone else. The gun that was ultimately found in that vehicle was also, according to Officer Candell, the registration was run on that vehicle. That firearm came back registered to the same individual who owned the vehicle. I don't know that there's been any evidence today to suggest that the defendant knew that the pistol was there. Obviously, we didn't hear any testimony about any statements made by my client or anything today. And third, that the defendant took part in carrying or keeping the pistol in the vehicle. I would suggest that those elements have not been met, and I'd ask that the matter be dismissed for lack of.
Today was the date that was set for preliminary examination. At the time of preliminary examination, the burden was on the prosecution. It's their duty to establish sufficient probable cause that a crime was committed and probable cause to charge you as a defendant that committed the crime. A probable cause is not a standard that is to be compared to the standard at trial if this matter is to proceed to trial. At trial, the burden is beyond a reasonable doubt, but at this stage, the burden is just more than mere suspicion. And it's based on the testimony and the facts and evidence presented at the hearing today. And the court is the sole determiner of credibility at the time of the preliminary examination. So we heard the testimony today of Officer Sagar Candell from Lansing Police Department about an incident July 11, 2022 in the area of Cedar and Mount Hope, City of Lansing, Kingdom County, making the view in this court appropriate. Without rehashing the facts again, so I think that we've heard them multiple times today. The criminal jury instruction, as indicated by the defense attorney, is that first, the defendant must knowingly carry a pistol. Does not matter why the defendant was carrying the pistol. I'm sorry. First, the defendant was in a vehicle that pistol was in the vehicle that the defendant was in. Second, the defendant knew the pistol was there. Third, the defendant took part in carrying or keeping the pistol in the vehicle. So as to these elements, the testimony, let's start with the stop. Got to consider the totality of the circumstances. The officer testified. It's about 3 o'clock in the morning. There's a vehicle that he noticed idling in a closed business in an area that he knows to be a high crime area, which causes him to monitor it. He's in a fully marked patrol vehicle. He is in a marked uniform vehicle as the officer is monitoring, then leaves, exits, and then pulls down and stops into another closed business lot, which then causes the officer some concern that there is, or some suspicion that there's something criminal happening. Then there is a broken tail light, and then the car or the vehicle exits and then crosses multiple lanes of travel. They make a left turn out of a right lane, which makes the stop appropriate just based on those things there. How do we get to the search? I think that the search would have been reasonable in the totality of circumstances, because as the officer was approaching the vehicle, he testified that he saw, he could not see the gentleman's hands, but it appeared he was leaning or reaching towards the back of the vehicle. Front window not being able to go down, he asked the defendant to exit the vehicle so he can talk to him. He testified that that the defendant gave consent to search. I don't have anything admitted into evidence to dispute that. So there was consent to search as far as we're concerned today. So for that reason, there was a proper search done. There was a firearm recovered. The officer testified that the firearm was located in the forecourt of the vehicle, and he said during the testimony that that was consistent with the area in which he noticed the defendant reaching. Now, vehicle is not registered to the defendant. Officer testified it's registered to the defendant's girlfriend. And that the firearm was also registered to the defendant's girlfriend. Girlfriend's not in the vehicle. It's 3 o'clock in the morning, and obviously, we have no testimony to say that he stole the vehicle or the firearm. He's operating this vehicle 3 o'clock in the morning, reaching in the area and where the officers locate a firearm. The court can conclude, based on the circumstantial evidence, that he knew that there was a pistol in that area and that he took part in keeping the pistol in the vehicle. Therefore, this case will be bound over to the circuit court for further proceedings. Bind over date's going to be August 10th. Do not need to appear in court on August 10th. That's just the date. The circuit court will get the file from this court. They'll set your next court date. Mr. Palmer will be made aware of that. There will be a pretrial in the circuit court. Okay?
Thank you.
No problem. Do you have any questions today, Mr. Clark?
Me?
Yes.
Yeah, when can I get up and testify?
Well, that's between you and your attorney. Today was a preliminary examination, though, so the burden is relatively,
And also, when can we get the video footage?
well, I don't have the video, so your attorney can get all the discovery he needs from the prosecutor or the police department. Okay?
I'll address it.
Do you have any questions for the court?
No, I don't.
Okay. Bond was originally set at 5,000, 10%. That will continue. Any additional matters for the record?
No, yeah.
No, no, thank you.
You are correct. So we know what's going on with Jay Wan. Where's Mr. Frylinson?
He was around earlier. I can try to find him.
Thank you.
Yeah, I can go check for other witnesses.
Sounds good.
Hi, Nick. Are you there? Nope.
On the record in the matter, the people of the state of Michigan versus Brian Beaumont Griffin. File number 22-01-768 FY. Council appearance, please.
Jessica Shaw on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Bomar Griffin.
Today's the date that's set for preliminary examination. And Mr. Nickel, last time we reviewed, didn't have discovery. Have you received the discovery?
I have the police report now. What I don't have, which I'm going to be in the process of requesting, is the MVR footage. My conversations with my client lead me to believe it's necessary for me to review that to decide whether or not it is appropriate in this case to run a preliminary exam and how to proceed with that preliminary exam if we do run it. So I was requesting an additional adjournment to be able to obtain that.
And you already, I found good cause the last time to adjourn, so we don't need to address the timeline at all. We'll go ahead and get you the date. I'm sorry. How long do you need?
2 or 3 weeks because it's getting the MVR footage from MSP sometimes. takes a little
That's
bit of
enough.
time.
That will go for you. We can do August 19th at 9:30. August 19th at 9:30. Do you have any questions today, sir? Any additional matters for the record?
No.
No, Your Honor.
Okay, we'll get you a copy of your notice for August 19th, okay? You're welcome. Okay, and then do you have witnesses here on J1 Bastion?
I did not, Erin went to go, sorry, Ms. Hostill went to go look for her. I did speak with her yesterday and confirmed that she would be here today.
Oh.
She's been here every other time.
There is a woman outside. Check them. What case are you looking for? I don't know if that's the case she said. Okay. Maybe possibly. Yeah. We have 2 things together.
One.
One in the world. Yes, so that one. Because he's got another case.
Oh. Yeah, I need to look.
Younger Bastion is going to be.
Mr. Carlson,
Yes, ma'am. I was down talking to Mr. Bay.
you're supposed to do that for today.
What's that?
You're supposed to do that before the day of the exam.
I did. One thing I wanted to think about every morning.
Okay, I don't know, where Mr. Bigelow went. I think you need to go pick someone up. But you have a couple things. What's going on with
We're
you?
gonna adjourn that out. Or she needs to sit down with,
Are they here?
she's here. You can bring her in.
Okay, let's handle that while Bigelow brings some.
I don't know, no, I was like, I don't know, wait.
All right, that's fine.
Said it better than anybody in the jail. I don't know if she was in the building. And now I'm making good news.
Right now, we're trying to deal with them too.
Let's deal with him.
Oh,
No.
you know, free sheet or is he pleading to the charge?
He did not take this yet.
No.
Claim the charge.
No, not to the charge, it's to misdemeanor and DOB.
I'm trying to find this picture, Your Honor. She was here. Maybe she went to put money in the restroom. I'm not sure.
On the record in the matter of the people of the state of Michigan versus J1 Bastion, file number 22-01816 FY. Council.
Jessica Shaw, on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Flagelson, appearing on behalf of Bastion. Mr. Bastion, standing or seated to my right, Your Honor. J1 Bastion.
Thank you. Today's date that was set for preliminary examination. My understanding is that there is a plea. Can you please state the offer on the record?
Yes, Your Honor, the defendant will plead guilty to an added count 2 of malicious destruction of a building less than $200. That's MCL 750.3805, and count 1 would be dismissed.
Your Honor, that is an accurate statement of what we wish to do today. Your Honor, the question I have for the court is, I know there's another pending case in front of this court where I believe this admission may impact his PA-53 bond violation. I think we can make an admission on that file for this plea this morning.
Oh, on the pending bond violation.
Yeah.
Okay.
I don't remember the file. Okay, a second.
That file? Okay, we'll have to record. She's gonna grab the file. You know where Mr. Carter is? That is logging into Zoom. Okay, in this matter, he still needs to be sentenced. Okay. Back on the record, I now have file number 22-01067, in which there was a PA 52 violation. So, Mr. Ferguson, your client's going to plead guilty to the added count 2 of malicious destruction of a building less than 200, and then I make an admission on the PA 53 violation.
That's correct, Your Honor.
Okay, Mr. Bastian, is that correct? That's what you want to do today? I don't know what that means. Oh, thank you. Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, thank you. Mr. Bastian, in the for today that you were set for an exam. You have the right to proceed to a trial on that matter. You have the right to have a jury trial. At the time of trial, you have the right to be represented by counsel. You have the right to remain silent and not have silence be used to prove your guilt. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecution prove each element of the charge beyond a reasonable doubt. You have the right to question any witness that the prosecution intends to call. You have the right to call your own witnesses or present evidence people would believe would further a defense to the charge. In order to plead guilty to the added count of malicious destruction of a building less than 200, you would have to give up each of those rights today. You understand that?
Yes,
Okay. You want to waive those rights today?
yes, ma'am.
Is anybody making any promises to you to get you to waive those rights? Is anybody threatening you to get you to waive those rights? Are you pleading guilty today because you believe you're guilty?
Yes, ma'am.
Are you currently on probation or parole?
Yes, out of Mason.
You're on probation in 55th? That's a yes?
Yes, ma'am.
Okay. You understand that a guilty plea could cause there to be a violation of your probation status?
Yes, ma'am.
Okay, you still want to waive your right to plead guilty?
Yes, ma'am.
You understand that a guilty plea could result in a conviction that you may need to report to your current job or to a future employer. You understand that?
Yes, ma'am.
I have an advice of rights and key information sheet that I stamped today's date on it. If that's your signature,
Yes,
you
ma'am.
read this document.
Yes, ma'am.
You understand all the rights there?
Yes, ma'am.
Okay, and do you have any questions about those rights? Okay, as to the added count two of malicious destruction of the building, how do you plead?
Guilty.
Then in file number 22-01067, there was a violation of the conditional release that you were previously arraigned on. Okay, the violation alleges that on July 8th, 2022, you violated the terms of your conditional release by making non-peaceful contact with the alleged victim in violation of the no contact order. As to that violation, how are you pleading?
Guilty.
Okay, that was factual basis, please.
Yes, Your Honor. Mr. Sebastian, I want to turn your attention back to July 8th of this year. Did you go over to 4062 Woodbridge Avenue?
Yes, sir.
That's here in the city of Lansing, Ingham County, state of Michigan.
Yes, sir.
And there lives a Selena Rodriguez, is that correct?
Yes, sir.
And you were under a no contact order, you couldn't go over to her residence, is that correct?
Yes, sir.
And you went over to her residence, is that correct?
Yes, sir.
And while there was her front door, is that correct?
Yes, sir.
And what did you do to that front door?
Kicked it.
And you intended to cause damage to that door, is that correct?
Yes, sir.
You weren't trying to go in the house you were trying to destroy the property, is that correct?
Yes, sir.
Your Honor, I have no additional questions.
Any questions from the prosecution?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea and your admission to the plea 53 violation. I find your plea be made freely, voluntarily, and intelligently. Was there restitution on this trial?
I don't have the amount of restitution.
Okay, so there is possible restitution. Oh. Accept this matter for sentencing. I also accept the other matter for sentencing. And we'll have restitution at that time. Do we need a restitution hearing, or you think that we just get?
I think you could just give a number. Here.
Don't necessarily think that he needs to have another evaluation, PSI, just because I don't see how it's gonna change much. So we don't need to go out to September for sentencing. We can do a sentencing quicker. I just want to give her an opportunity to get the restitution so I can order it all at the same time.
Judge, I think we set sentencing 220167 for next Friday the 5th.
Did we? Okay, well, then we'll set sentencing on this matter for the same date. August 5th at what time? 8:30. 8:30 in the morning. Oh, any additional matters this time?
No, Your Honor.
Judge, may we address bond?
You may.
All right, I do know bond is presently set at 10,000, 10% in this file, Your Honor. I think the bonds, he already posted in the other file, and I think was held on the 53 violation. I would ask that both that he be allowed to be back out on 220167, then he can post the present file, Your Honor. He need to be allowed back out in the community. He can be monitored on GPS tether. He is aware of the no contact order. He is allowed to have contact for purposes of arranging childcare that was already ordered from the previous plea back in June. I'd ask that those orders be continued.
I revoke that. No contact order. At the last hearing. There was a no contact order originally, and Ms. Rodriguez came to court during the plea and pleaded for the court to allow for there to be contact because, and I quote, that's all she had. I cautioned her about that. I still gave her the benefit of the doubt, and here we are today. And so the no contact order is in place. There's not to be any contact directly or indirectly with Selena Rodriguez. If you need to make arrangements about child care, you need to do that through the family court. I will grant the request to amend the bond on this file. It was actually 15,000, 10%.
I apologize.
I'm going to amend it to 15,000 personal recognizance with GPS tether. Again, no contact order with Selena Rodriguez. You have to be within 1,500 feet of wherever she lives, works, or goes to school. You have to have contact directly or indirectly with Ms. Rodriguez. You're not to engage in any assaultive or threatening behavior. You understand that, sir?
Yes, ma'am.
You can appear for your sentencing via Zoom. We got Zoom information as well. Do you have any questions at this time?
No, ma'am.
Any additional matters for the record?
No, Your Honor.
No, Your Honor, thank you.
Thank you. You're all set. Who do we have here? Okay, Adam. Mr. Abbott.
Good morning, Your Honor.
Good morning. How are you?
Well, considering I'm pretty good.
Okay, that's good to hear. Mr. Carter, Ms. Blackman is on Zoom.
Pardon?
Your client is on the Zoom. Ms. Blackman, can you hear me? You're muted, ma'am.
Yes, ma'am.
Okay, you were supposed to be here in person for an examination.
I thought it was via Zoom, Your Honor. I apologize for that. I've had a lot of court dates this week.
Oh. Have you spoken to her recently?
Spoke to her 2 days ago.
Okay, so
I am,
you don't need to speak to her now then.
I'm sorry.
I just wanted to know if you needed to speak to her now. I'm just gonna give her a new date.
I did, yeah, I was going to say that I did not verify that it was a new person, and I apologize.
No worries. I just wanted to know if you needed to get on Zoom to talk to her, but if you already spoke to her this week, that's fine. Ms. Blackman, I'm gonna get you a new date. You have to appear in person on this file, okay?
Okay,
Your Honor, I'm on vacation August, the week of August 8th.
So you can't come to court from vacation? No, that's no problem.
August 5th.
Yeah,
That's the
scare
same
me.
No, August 8th is a Monday. No, he said August. He's not gonna be here the week
Oh,
of
okay.
August 8th.
August 5th works for you?
August 5th.
it's good. It's good.
What time? At 9 a.m. Okay, you're gonna get a notice to come next Friday, August 5th at 9 a.m. in person, okay, Ms. Blackman?
Ma'am, I have a court hearing for my minor child. She is in some legal trouble at that same time, so
Okay, give me another date.
Looking at my schedule on August 8th, not work then, because I'm in trial.
You said August 8th will not work. But you're saying on vacation.
Here.
We were gonna go 2 weeks out then.
August, if it's August 19th, I'm in, do you do them on Fridays?
Thursday or Friday.
Okay.
I apologize.
Oh, I didn't know if you had something.
I'm in
Okay.
Eatontown all morning on Thursday, the 18th and the 19th. And then I start a trial in front of either Judge Kennedy or Judge Aquilina the following.
Following, all right, well, sounds like we'll do it in September.
September 2nd or 1st. I hate to say that. 'cause it sounds like I'm
September 1st
dictating.
At 9.
At 9. Okay, Ms. Blackman, September 1st at 9 in person, okay?
Yes, ma'am. I will see you September 1st at 9 a.m. in person.
We're gonna send you a copy of the notice to appear, and it'll say in person on it. So if you ever get confused, just look at your notice and see what it says, okay?
Okay, thank you, ma'am.
You're welcome, you're all set.
Thank you, Your Honor.
And let's see. This was Ms. Adams. We're on the record in the matter of the people of the state of Michigan versus Amy Adams, file number 21-02530. Council appearance, please.
Jessica Shaw, on behalf of the people.
Good morning, Your Honor. John Abbott representing Amy Adams. I don't see her.
Thank you. Today's the date that was set for preliminary examination. And I believe we are we resetting this? Is that what's happening? Mr. Abbott?
I guess we will, Your Honor. I didn't know if she would be transported to from Eaton County Jail or not. Apparently not.
She's
So
here in the
resetting it is
courtroom.
a good idea.
She's here in the, I'm sorry?
You have to go down and get her.
Oh, he wants to go get her. You're not Amy Adams.
Yeah, I'm Amy. Oh.
That's what I was
Amy's
about to say.
here.
Am I missing something? I thought I was missing something. She's right here, sir.
Cool. Well, that's good news, Your Honor.
Did you need to speak to her?
Yes, please.
Yeah.
Okay, we'll get her on Zoom. Okay, I don't know who Bigelow wants to go get. Who did he go get?
Well, he probably wants to go take him down.
Okay, but what about Purnell? Is he bringing Purnell up? Because he should. Does he has radio? Can you take radio? We took care of Beaumont Griffin already, right?
Yeah. Yes, sir. Are you bringing Mr. Purnell up with you? Want to do that?
Are we running that?
No.
And I don't see Miss Donnelly. Yeah, he can bring her, he can bring Purnell up.
Yes, Nick, go ahead and bring Mr. Purnell up when you're done.
And then we'll do Ryan because Miss Donnelly's not in here. But that's gonna have to be a wait. We have to waive that one.
I can step out for a second. Right?
I'm sorry?
Can I step out?
Oh, absolutely. We're just gonna get her on Zoom to talk to her
Okay.
attorney.
Down here.
Oh, he's
Thank you.
here.
Thank you.
She just asked me to Mr. Abbott.
Yeah, the one conference room down there around the corner. It's open there. See, I was going there.
Thank you.
She left before she.
Want me to hold it?
Okay, she has something else said?
Ms. Blackman called me and said that she had a warrant on this case. Is that true? And what can we do?
In this case?
Yeah, that's what pretrial services.
Attempted to contact you via telephone. It looks like she needs to make sure they have, well, she hasn't returned my phone call to them. I don't see where I issued a warrant. Is there a warrant on Jacob Blackman? I don't think that's right.
I know there was an issue with her not reporting, and I got that straight.
Okay, this one is from the 25th, so a couple of days ago. I know we sent, it says they made attempted to contact her via phone multiple times, left multiple voicemails, and she's not returned the phone call.
There's no warrant.
But I didn't issue a warrant.
I got that straightened out. She indicated to me she had talked to pretrial services yesterday.
Oh.
They were,
Driving while license is suspended.
She has a warrant on the driving while license is suspended.
Go get it.
Yeah, you can go get it. I'll reset it. And you can let her know the date for that one.
Sorry.
We'll reset that one if you can let her know the date.
Sure.
'Cause I think it was a failure to appear. Okay, and I choose here, correct?
That-
Mr. Carlos was supposed to go find out for me. I choose here. We're waiting for them to bring Canelo up and then. Cody.
Rob Paul.
I forgot to order the transcript.
Oh, I thought she was in the hallway. Did she come? Is she still out there?
She-
The clerk's office.
My
Oh.
client was here. I think she may have just gone to one of the meters, but I haven't seen her.
Which client is this?
Shannon.
That's a long meter trip.
Fair enough, Judge.
So
And
I'm
on free
go-
parking Friday, Your Honor.
Yeah, it is free parking Friday. It's definitely free parking Friday, but you told me that, like, you know how many cases I've handled since then?
Yeah, that's what I said.
I think
I'm just
she
saying, I don't know
did
where she
a little
went.
dash.
Yeah.
So we're gonna go ahead and see if we can recover her to the court via bench warrant.
Yeah. Yeah. Thank you, Your Honor.
How did that go? Did you run it in yet?
Oh, he,
Although she might not have caught up.
wants the, a transcript.
Yeah,
Oh,
I'm sorry, I forgot.
okay.
I just stood up and walked out.
It's the 17 one, but it's
Don't put
that
the
one, they were all
bother of
together.
Cutting off your tether and then decide to use your body as a driver for a bunch of
And
crimes.
that's before Judge.
Oh, God, yeah.
Judge Ward issued a bench warrant for this? I don't think so. Well, that's that file was with her.
Judge, she's on her way back. She was- I'm not sure where she was.
I don't see a warrant here. Let me see. Failed to pay. Oh. Yeah, well, she's gonna have to log in to be arraigned on that one. Mr. Carter. That matters before Judge Ward. She has a failure to pay. So she just needs to log in. She could be arraigned on that.
She needs to.
If she can log in, I can arraign her on it and she can log back in. Okay, this is Ms. Purnell. We're on the record in the matter of the people of the state of Michigan versus Janine Purnell, also known as Janine Black, file number 22-01793. Council appearance.
Jessica Shaw on behalf of the people.
This is Public Defender Scott Nichol on behalf of Ms. Black.
Today's the date that's set for preliminary examination. We reset this because Mr. Nichol, you needed some discovery. How are we proceeding at this time?
At this time, I would be asking for an additional adjournment. I received the discovery yesterday at about 2 o'clock. It was 88 pages long. I've had a chance to start to review it, although I have not reviewed all of the details. But my conversation with my client this morning lead me to believe that the body cam video and the video of her interview with the police are necessary for me to procure prior to conducting a preliminary exam. And so I'm asking for an adjournment so I can obtain those things. Believe 2 weeks should be sufficient because both of those things should be in the hands of Lansing Police Department.
August 11th at 9:30. Any additional matters for the record?
No, yeah.
Your Honor, I would like to address Ms. Purnell or Black's bond at this time.
Okay,
She is currently being held on a 5,000 10% bond in this file. We would be asking for that bond to be converted to a personal recognizance bond. She is currently in the Ingham County Jail being held on a serving a sentence, essentially. And once she is done serving that sentence, she would be released on probation in front of the 30th Circuit Court. Part of her probation conditions is that she have a 90-day MDOC GPS tether. And so if she were released following that sentence, she would be on tether. The court would be able to keep track of her. Represented Ms. Black in the past. She's never missed a court date before. Never had any issues getting in contact with her. So I'd ask the court to convert that to a PR bond so that this file does not continue to hold her once she is done serving her sentence and clears up the matters revolving around her probation in 30th Circuit.
I'll amend the bond to $5,000 personal recognizance. All other bond conditions will continue.
Thank you, Your Honor.
Any additional matters for the record?
No, yeah.
Nothing further for the record.
Thank you, sir. And Ms. Blackman, can you hear me?
Yes, ma'am, very much so.
Thank you. We're on the record in the matter of the people. Of the city of Lansing versus Adrika Blackman, file number 17-05845. And Ms. Blackman, there was a warrant issued by Judge Ward on this matter because you owed some money on this for quite some time. Looks like you still owe $940 on this matter. If you were on a payment plan since 2019.
What is this regarding?
This is a driving while license is suspended.
Okay.
Just trying to follow this here.
I can make a payment on the 3rd. I get a fixed income now because of my health, so I now have the income to pay it. So if I could get on the payment plan again, I'm sorry.
The it looks like there's another case added to this payment plan, so it's more than one case included here. So the 17-05845 is the driving while license is suspended. There's also in this amount included your fines and costs from file number 19-05127. And that was a retail fraud. Okay,
Yes, ma'am.
so I'm going to refer you to collection so that you can make a payment plan with them. So long as you stay consistent with whatever your agreement is, you won't get another warrant, okay?
Okay, thank you, ma'am.
What's your phone number?
517-214-0651.
Okay, so I'll note that number so collections can contact you to address your payment plan. You're all set on this matter, okay?
Thank you, ma'am.
You're welcome.
Does this mean the warrant's gone? I won't have the warrant no more?
That's correct.
Okay, thank you, ma'am.
You're welcome. Okay. Do we know where Bigelow went?
Probably downstairs.
Probably taking Purnell back. You need
Cody Ryan, yeah.
Cody
He should
Ryan.
be appearing.
Oh, he's gonna appear virtually. you said?
That's what Nicholas said. that he
Okay,
was gonna-
sounds good. Who's this, sir? Who's this?
Oh, that's pretty right.
I thought he was gonna log in for us. Okay, sounds good.
All right, I mean, maybe long enough. He wanted to come up there.
They don't have anybody down there doing the podcast.
Oh. That's because it's Friday. Interesting.
Feel good, see you later Friday.
Feel Good Fridays. There we go. We're on the record in the matter of the people of the state of Michigan versus Cody Ryan, file number 22-01748 FY. Council appearance, please.
Jessica Shaw, on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Cody Ryan, who is standing to my right.
Thank you. How are you, Mr. Ryan?
Good, man.
Today's the date that was set for your preliminary examination. And my understanding is that your attorney would like to have an adjournment so that she can file a motion to suppress. That's correct? Well, that's correct, Ms. Donnelly.
Yes, Your Honor.
Thank you. Any objection?
No objection, Your Honor.
Okay, you're requesting 30 days? for
Yes,
this?
I believe that it should be sufficient time for me to write it and then have the prosecutors have their time to reply.
Mr. Ryan, you have the right to have a preliminary examination within 21 days of your arraignment. You were arraigned on July 14th. Your preliminary examination was scheduled for today to fall within that time frame. But because your attorney wants to file a motion to suppress some evidence, are you willing to waive your right to have that examination within 21 days so that we can get you a new date?
Yes, ma'am.
Okay. Is anybody threatening you to get you to waive it 21 days?
No, ma'am.
Is anybody promising you anything?
No, ma'am.
Okay, we'll get you a new date.
September 1st at 9:30.
September 1st at 9:30. Any additional matters for the record?
No, Your Honor.
None from the defense. Thank you, Your Honor.
You're all set.
Thank you.
Okay, Mr. Adams, we have Ms. Adams back in the room, back on the record in the matter of the people of the state of Michigan versus Amy Adams, file number 21-02530. Mr. Abbott, you met with her privately and you're requesting an adjournment, correct?
Well, unless we can enter a plea to a misdemeanor today, Your Honor.
Was there a misdemeanor offered?
Well, back in May there was, but I'm not sure if it still holds up.
If we receive proof that she was in drug treatment court somewhere, then she can have a misdemeanor. However, I have not received any proof.
So it looks like they're still waiting for some evidence that she was in treatment.
Right, Your Honor. Well, she's either going to be accepted into the Eaton County treatment court or she's just going to be sentenced in Eaton County without treatment. She's due to be sentenced in Clinton County on the 15th, but that'll be just a time served. I currently today have no written proof that she's going to get into the Eaton County drug treatment court because it's they still are waiting to screen her. They thought they'd have it screened by earlier this week, but that wasn't done. They've adjourned the Eaton County status conference to August 19th. So she'll be back in front of the judge in Eaton County on that day. But it's, I guess it's up to the prosecutor either way. I think she's going to end up in drug treatment court.
Okay, well, Ingham County prosecutor says they need some evidence if that's the case, and they don't have that at this time. So we can adjourn this. It's up to you if you want to adjourn it till after she's sentenced in Eaton County. We can do that. Otherwise, I'll set it for the next available date. We can run the exam.
All right. Well, we don't want to run the exam, Your Honor.
Okay, so we'll
we
set it
want to.
after. She has it. Sounds like she has a hearing on the 19th of August
Yes, Your Honor.
in Eaton. So let's set it after that.
Okay.
We can do August 26th at 9:30.
August 26th at 9:30.
Your Honor, I'll be that date definitely rings a bell. Unfortunately.
Okay.
How about the next?
Well, September.
We can do September 2nd at 9:30.
September 2nd at 9:30.
Here we go. Actually, Your Honor, I apologize. The 26th is better than the 2nd. Either way, I'm in trouble, but
August 26th. Okay, August 26th at 9:30.
thank you.
All right. Do you have any questions today, ma'am?
No, ma'am.
Any additional matters for the record?
No, Your Honor.
Okay, you're all set, Ms. Adams.
Thank you.
That concludes my morning docket. I don't have anything else. That's good. Thank you, Mr. Abbott.
Thank you.